They're roofing above me, so if I jump or make a face, it's because it sounds like somebody's about to crash literally through my ceiling on top of me.
All right, so we are recording and live and ready to go.
Sounds good. Well, good morning. We will call the Zoning Board of Appeals hearing of April 1st, 2021 to order at 11 o'clock. Pursuant to Section 70 of the Illinois Open Meetings Act, the March 5th, 2021 gubernatorial disaster proclamation and the written determination of the Zoning Board of Appeals chair a public meeting can be held by audio or video conference without a physical quorum due to public health concerns. This meeting is being conducted by audio video conference. The meeting is also being recorded and live streamed at lakecountyil.gov/watch ZBA to allow members of the public the ability to attend the meeting. In-person attendance was also made available at 650 West Winchester Road in Libertyville and is limited to the number of individuals practical in keeping with social distancing. As a reminder to board members, if you're able to share your video, please do so and remain muted unless you are going to talk. If you have a question, feel free to raise your hand. At this time, we'll have a roll call. Brad, if you would do that.
Member Raymond.
Here.
Member Hockney.
Here.
Member Peterson.
Here.
Member Roche.
Here.
Member Starkey.
Here.
Member Rindle is currently not present, is working on it. And Chair Kaplan.
Here.
We currently have 6 members.
Sounds good. Thanks, Brad. We will dispense with the pledge. No other items added to the agenda or deferred business that I'm aware of. So with that, we will turn it over to staff in the Lake County State's Attorney's Office for our updates today. So Krista and Brad.
Okay, yeah, let me get share my screen here, make sure I'm hopefully you can see slides there. I want to make sure. Sorry, I want to make sure I'm sharing the right screen here. Hopefully, can everybody see that the slideshow there?
Yes.
Okay, great. Thank you. Good morning, Krista Brown, Planning and Zoning Manager. Thanks for joining us today. We wanted to take a moment to just go over the text amendment process in general, specifically to discuss this process. Back in February, Lyle Stalter did a great job going over changes to the Open Meetings Act and discussing variances and CUPs specifically. But in anticipation of having several packets coming your way over the next several months, we thought it would be helpful to just also take a little bit of time to talk about this topic specifically. So my intention is to keep it informal. It shouldn't take us too long to go through the materials. But if any board members have any questions at any time, please feel free to just interrupt. And as well, we have Lyle Stalter and Dan Brown from State Attorney's Office. I would encourage Lyle and Dan to jump in whenever they have some additional thoughts or comments that they would like to add. And we'll have Eric Wagner joining us momentarily once committee meeting wraps up this morning. So jumping into the first bullet there. So a text amendment is basically any amendment to the text of the UDO. This is different than a zoning map amendment, which is zoning of parcel. So any person can actually file an application with our office to make an amendment to the UDO. Or they could also be a staff or a Lake County Board initiated amendment. So there are 2 types of amendments. One is a comprehensive amendment, which is considered a substantial addition or an alteration to the UDO, and this is what would represent a policy or specific change in how the ordinance is applied, versus a housekeeping amendment, which is a minor modification to the existing text of the UDO. And this would just be to clear up any something, maybe there's some conflicting sections, or there's some confusion to, so we would want to clarify the language, the intent, and certainly even like grammatical or typographical errors would be considered a housekeeping amendment. So the legislative process for text amendments, it starts at the ZBA. So you are the first, I guess the first point of the process. You hold your hearing. You have, there's a series of approval criteria. And so then you would make a recommendation after holding that public hearing, listening to the comment, considering the amendment, and then make a recommendation. And then that recommendation gets passed up to the Public Works Planning and Transportation Committee. And they also review and consider the amendments, make any suggested edits or changes to as they see fit, and then they pass their recommendation up to the Lake County Board. So after receiving the recommendations of the ZBA and the PWP-PT committee, then the county board has then it's their time to review the application, and they can either approve it, they can approve it with some modifications, or they can deny the proposed amendment. Again, based on the text amendment approval criteria. One item to note is that amendments to there are two sections of the ordinance that deal with subdivisions and school and park contributions, and any amendments to those sections of the ordinance go straight to Public Works Planning and Transportation Committee rather than the ZBA.
Hey, question.
Yes, go ahead.
So I just wanted to backtrack just a little bit on the legislative process. Most of you already know this, but just wanted to state it since we're going through this, is that when a text amendment comes to you, it actually starts at the county board. And then they direct the ZBA to hold the hearings on the text amendment. So you're generally, I would say 90+% of the time, sometimes it changes depending on the issue that is the basis of the text amendment. There's already some language that the county, probably through the planning staff, has developed for that text amendment. So then the county board will then direct the ZBA to have the hearings, and then that goes through the rest of that legislative process.
Yes, thank you for that clarification. So in the case of a county board amendment, the resolution directing the ZBA to hold a public hearing is in fact the application that staff acts on. So there is the possibility for someone to file a protest petition. So just as someone could in the case of a rezoning amendment, if a protest petition is filed, then the amendment requires an affirmative vote of at least 75% of all the members of the county board. And then moving on to the approval criteria. So there are three main points that to consider when looking to make a recommendation on text amendments. The first one is a correction of error or conditions. So basically, does the proposed amendment correct an error or inconsistency, or does it meet the challenge of some changing condition? The second criteria would be, is the amendment consistent with section 151.005 of the UDO? And that is the purpose and intent. There's 19 or so criteria within the purpose and intent section. One of those is protecting landowners from adverse impacts associated with development. So there's a whole list of different criteria just within the purpose and intent of the UDO. And then finally, the third criteria is no adverse impacts. So does the proposed amendment not, I mean, you have to look at it in terms of, will it not adversely affect the health, safety, morals, and general welfare of the public? And so that's really the three standards that you're considering when you're making a recommendation on a specific amendment. So then getting to the hearing agenda itself. So amendments follow the same agenda as your other types of hearings like CUPs and variances. The public comment, the rules are the same as they would be for those hearings as well. So there's, unless otherwise, unless the chair makes some other determination, there's a maximum of 3 minutes allowed per individual that wanted to make a public comment. If comments become repetitive in nature, if there's no new information or testimony being presented, those may be discouraged from individuals. The chair doesn't have to necessarily allow every single person to speak if those comments are basically the same in content. Speakers are limited to speaking one time only unless they have some new information that they want to present. And finally, comments must be civil in nature. There's two other types of ways that the public can participate in your hearings. One is by a recognized organization. So this is any organization that has some special interest in the public hearing. So in the case of a text amendment, say, there's an amendment being proposed on the topic of beekeeping, and the Beekeepers Association of Illinois, I'm making this up, say that they want to present some information. And so there's some special consideration that's given to a recognized organization. They're allowed to make a presentation, and they have within the order of proceedings, they're allowed to they're given different consideration than just somebody making a public comment. And then finally, we have the interested party cross. So if any interested person desires to cross-examine a witness, they can fill out the appropriate form, and they would also be given some special allowances within your agenda. Typically, I think, we had this discussion with Lyle earlier this week. In the case of text amendments, that's not something that necessarily would apply. That was probably something that you'd see more in the case of a variance or CUP hearing. So we can go over, I do have your rules, the order of proceedings that we can pull up and go over specifically. Lyle, if you wanted to touch on anything additional with in regards to the organizations or interested parties. And I'm not sure, I don't believe Eric's been able to join us yet, but that was just the content that I had to share with you, unless Lyle wants, I'm sure you might have some additional things to add.
So just really quickly, because I think Krista covered it very well. I mean, obviously public comment, those are individuals who just want to provide essentially their thoughts, their considerations, their concerns to the ZBA that might raise questions for you as you're considering the text amendments before you. They are not individuals who are subject to cross-examination. They're not presenting in the context of evidence, like true evidentiary information that you would be looking at or considering, like a petitioner would be presenting you evidence for that application. But it's more of, these are my concerns. As a person who's going to be affected by this amendment, please keep this in mind, and on controversial ones, you might just get basic objections. We don't think that this is appropriate. Or, sometimes you get a text amendment on beekeeping that everybody's like, yeah, bees are great. Or then you have the neighbor who says, those bees are going to be flying over my property and stinging my kids when they're playing out in the yard. How do we protect against that? So, but that's just people who just want to provide what their concerns are to the ZBA. a lot of times what public comment will trigger, because they're not actually asking anybody questions, there's no response to that. But it might trigger questions that you as a board considering this might have for somebody else who is presenting information or testimony. So like Krista had pointed out, if it's the bees, it's a good example to use today. If it's the bees and you have a recognized organization that's presenting, somebody who's giving public comment doesn't have the right or ability to ask that particular presenter questions or information, but you as the ZBA might have had some questions or comments. The only challenge is I think the public comment comes after those presentations, but I know a lot of times that you will go back before you make your determination, and if there is a question that is raised from somebody who's presented, you will still ask it during your deliberation process as you're trying to come up with what your final determination will be as a board. So that's the one thing to keep in mind about public comment. That's usually how the public will participate. They're not going to participate as a recognized organization generally unless there is a recognized group, beekeepers, or if it's affecting particular properties, homeowners associations who think that their property is going to be affected by a particular text amendment. Might be a recognized organization that's going to try to that wants to present evidence to you to consider. But if they're a recognized organization, then they open themselves up to that cross-examination. Obviously, not only from you, but from the actual petitioner and potentially from the interested parties who want to make sure that all of the relevant information is before you as a board to consider. And then there obviously is the interested party person who has the ability to ask questions. I mean, to just make sure that everything is being considered. Those were the only additional comments that I had before you kind of get into the agenda process, Krista.
Okay.
Dan, I don't know if you had any.
I do not.
Okay, so I'm going to pull up the order of proceedings here, and this is in your bylaws, so you should all have a copy of this. But we'll go over it specifically just so you know you have it fresh in your mind. So the order of proceedings.
Can you make it a little bigger?
Sure.
My eyes aren't that good.
Give me just here. Let me do this. Give me just a second to. There we go. So I'm not doing. I'll do my zooming off. Okay. Let me reshare that. Is that better?
Much better, thank you.
Okay. So obviously, all your meetings start off the same way. Oh, and that was, I think, the other point is just administrative appeals. Those types of hearings follow a separate process. So your hearings all start off with obviously, call the roll call, the Pledge of Allegiance, preliminaries by the chairperson. And this was where if one of those folks has submitted a form to staff, we would pass that information along to the chair, and he would identify those parties that may be participating in those extra capacities. And then that would go into a staff presentation, followed by presentation of evidence if there's a petitioner or their representative. And this is where time is allowed for the ZBA to ask questions or those interested parties to question those witnesses. So that would follow those steps there. And then that would be followed by, so if in the case of text amendments, if there was the Beekeepers Association wanted to make a presentation, this is the time and place in the agenda that they would be allowed to do that. And so they're actually could provide testimony up to a maximum of 30 minutes. And then they are subject to questioning by members of the ZBA as well as any of those interested party folks. And then moving on after the close of that testimony, then we move into the public comment portion of the hearing, and that's lists out those rules that we already just discussed a little bit earlier. And then finally, the recognized organization is allowed to make a closing statement. So after we get through all of those public comments, they can kind of make a one last statement, and that's allowed to for a period of 5 minutes. And then followed by the closing statement by a petitioner or representative, if there is one. And then we would move into deliberations by the ZBA. And so in the case of text amendments, we'll present staff would give a high level overview of the amendments that are being proposed, and then we would go through the amendments specifically. If there are areas that the ZBA wants to make changes, so you can, for those of you who haven't been through the process before, as part of your recommendation, you're allowed to make changes, either adding sections, deleting sections, making numerical edits, things like that. So all of those changes so that it becomes a set of amendments that you feel meet the criteria, the approval criteria, and that's what you would be basing your recommendation on. And so finally, we would close testimony, and then you would make your recommendation formally. And then that recommendation, like we had mentioned, gets passed up to PWPT committee. And then they consider what staff was, what the draft amendment was, what your recommendations were, and then they make their own recommendation. So any questions on that specifically?
So I'm going to jump in really quick before I forget. One thing that we did not really address is because now hearings are being held under Section 7E of the Open Meetings Act, which is allowing the virtual remote attendance, right? Normally, when you would have a text amendment, public hearing, or anything else, you would have the public who was interested in that particular topic come to your meeting, fill out their information saying that they wanted to address the ZBA, address you, and then they would have that opportunity to do that. So it's going to be a little bit different in this context because of the remote hearing process that we're going under. Obviously, they're not going to be in the same room with you. They're still going to have to provide information to the planning staff that they want to participate. So there'll have to be an opportunity for them to indicate that they want to provide comment. But we also now allow for written comment, which is probably not something that you've seen a lot of in the past when you're dealing with hearings and amendments. And so, there's that comment would be part of the record because it's being presented to you as a ZBA making a determination. And discussing with planning, I think we kind of thought about the best process would be to present those to you to the extent possible. Obviously, it depends on the numbers. If you just get a handful, it's easy to read those into the record. But if you get a lot of public comment, you do have a 30-minute time frame within which public comment needs to be provided. However, one way is to provide you the written copy and you can read through them and have a familiarity with what the issues or questions that the public have with respect to the amendments that you are considering. So just kind of keep in mind that this is going to be a little bit different process right now because we are still in the remote hearing context and not doing fully in person where there was a limitation usually on or limited number of written comments when it was under that process. Chris, I don't know if you have anything to add with respect to how that's going to play out for the ZBA in the upcoming hearings.
So I think as we have done in the past, we'll continue to work closely with the chair as we move closer to different hearings. If we start getting a lot of public comments, obviously we'll keep the chair informed and just work. I think the approach will be to just do it as a case-by-case basis. So, and just what are the current requirements with regards to meetings at that time, so I'm trying to, I guess I'm talking generally, not just within the next 2 months, but maybe what we're going to be looking at in September, our conditions going to be a little bit different. So I think one thing that, or if anything that I've learned over the past year is that you have to be constantly adapting to change. And so we'll always do the best that we can to one, meet the requirements of Open Meetings Act and everything else that we have to require, but two, give the information so that the ZBA, so that you as a body can do your work. And so, I think communication is the key there. So staying, if it's helpful to read through every comment during the hearing, then that's what we can do. So just trying to be cognizant of those factors. So that was all that I had to review this morning. Do any of the ZBA, do you have any specific questions or anything you'd want to talk about a little bit more? If I breezed through one section too quickly, let me know. We can kind of revisit it. Brad, if you have anything that you'd like to add.
No, Krista and Lalik had touched on it. And I think only members Raymond, Reindl, Hockney, and Chair Kappan were at the most recent text amendment where we had members of the public, and that involved the chicken coops and the bees. And we had members of the press there, and we reserved Independence Grove, and there was about maybe 50 people in the audience. That took 2 days, and not to get specific, but the text amendment we have coming up will probably take 2 days, and we let them speak, and that their comments went into the record. So that is the best example I can recall where we had a text memo with members of the public attending.
Yeah, I can't think of any others either that we've had at that amount of participation. And we let them all speak, which worked out well. And I think it was important to have them all be heard as well.
That was the most recent one. The wind turbines one in 2010 we had a lot, but that the chicken coops and the bees, because in 2014, 2013.
And we had a lot of that one down on the Lake Zurich years ago. We had like 5 nights.
Yeah, that was, I think you might be referring to DiMucci, which was an actual proposal, but
Right.
text memo is a bit of a different process.
But that was an example of a hearing that went over multiple dates, right? I know the solar amendments, the most recent packets that you had were the solar amendments and then the general comprehensive updates. In the case of the solar amendments, we did have a handful of people that did participate in making public comment there too. So, any other questions, comments, concerns?
Board members have any other questions? Lyle, anything else from your office that you wanted to make sure we follow?
No, I think that's pretty good. I will be attending the upcoming text amendment hearings that you have. So obviously be aware of that. I don't always, but when it's something that's a little bit bigger, we participate.
Good. And I just saw, as we were on this call, I saw a press release did go out from the county to the public announcing those hearings coming up. So I assume staff, if they get any comments, will start in the next several days or weeks as well.
Mm-hmm. Yep, we'll be watching out for those and packaging them to get them to you, to the board. So Greg, I will. That's all I had. So I'll turn it back over to you.
Great, sounds good. If there's not any other questions, any of the board members, staff, anything else that you've got as an update? I think our next hearing, am I correct, is the 8th? I don't have my calendar in front of me.
It is April 8th at 9 a.m. It's a variance hearing.
Perfect. Anything else from any of the board members or staff before we let you go? Well, seeing none, hope you all have a great Easter weekend. Enjoy the time with your family, those of you that are going to be with them, and pass over to all the others. And happy opening day to the Cubs and Sox fans. So hope we get a win there too. Anyways, with that, a motion to adjourn would be in order.
So moved.
Sounds good. With that, we are adjourned. Everyone have a great day. Be safe.
You too, Greg.
Thank you.
Bye.
Bye-bye.
Bye, guys.
Safe travel.